So Dushyant, let's come to you first. Since you argued in the court and we've seen a clear split verdict, Justice Gupta is very clear that a hijab is a reasonable restriction that a school can put because a school has the right to impose a sense of uniformity, and secularism, he says, does not mean that any religion is given any preferential treatment when it comes to a dress code. On the other hand, Justice Dhulia believes very differently that right to religion under Article 25, right to freedom under Article 19 allows people to wear the dress they choose to. How do you see two such contrasting views from two judges, Mr. Dave?
Well, it's not so easy an answer, but I can definitely say one thing with greatest respect to Justice Gupta, whom I really admire, that he is completely wrong. I don't think he has understood the Constitution. I don't think he understands the scope and ambit of the freedom of religion that the constitutional framers, provided in our Constitution. I, in fact, cited the Constitutional Assembly debates, which before the bench. And throughout the debates, the members after members of the Constitution Assembly, including T.T. Krishnamachari, Kanayalal Munshi, and Santhanam, many others, repeatedly said that Article 25, which was old Article 29, Article 19, is an article of toleration. And they said that we must therefore allow every kind of a belief by any religion, and not just a belief, but the conscience of the people who profess the religion and the practices which are followed by them. Now that's precisely what the Supreme Court's 7-judge bench has earlier said in Shirur Math's case, that these are all expressly protected. Therefore, I don't think that Justice Gupta's view is at all in consonance with the Constitution, in consonance with the previous judgments of the Supreme Court. And I think I would much rather say that Justice Dhulia has taken an eminently just and legal approach, and I commend that for acceptance before the nation.
No, you're emphasizing Article 25, freedom to practice your religion and hold religious beliefs. However, Justice Gupta has said, and I quote here, government order, that's the Karnataka government order, promotes uniformity, encourages a secular environment, order in tune with the right guaranteed under Article 14 of the Constitution. Therefore, he claims that the right to equality is strengthened if you have a uniform dress code, and it is a reasonable restriction on Article 19 as well. That's so, there are two different, while you say that Justice Gupta has got it wrong, his proponents would well argue that he too is following a constitutional principle.
No, I don't think I can agree to that view of Justice Gupta, for the simple reason that right to equality does not take away freedom of religion. Freedom, every article, of the Constitution, the fundamental articles, spring into being all the time. And therefore, you can't say that one article is at the cost of another article. Certainly not. So, giving that into, play, I personally feel that freedom of religion does not stop at the school gate. The freedom of religion, in fact, continues for every child who is studying in a school. And as I had told judges, that look, nobody is saying that there should be no uniform. The color of the hijab was also the color of the uniform of the colleges. And therefore, these are not, this is not military you are dealing with. This is schools where, every child must have a right to express his or her freedom. And if you try to curtail that by saying that, oh, we have a, right to put some kind of a restriction in the garb of equality, I don't think equality principle can be evoked to the extent that they have done. Okay. So I honestly feel that Justice Gupta has gone terribly wrong in the view that he has taken.